Next up on This Week in Law, are you sick of elves and reindeer? Never fear, because we have trolls and revenge porn for you. With Professors Paul Heald and Joshua Gans, we're going to be stashing our kids, Google Glass, and digital diapers in the trunk. Next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown. Episode 239, recorded December 13, 2013. Digital diaper, your data is crap. This episode of This Week in Law is brought to you by Tonks Coffee. Tonks offers a bi-weekly subscription. Tonks sources their beans directly from the growers. They're roasted and shipped within 24 hours, giving you the freshest coffee beans in the world. For a free sample, visit tonks.org/twit. That's tonks.org/twit. Hello, I'm Denise Howell, and you're joining us for This Week in Law. I'm really excited for this week's guests because although they don't know each other, they tell me they both have intersecting interests and expertise in digital business and economics, which I think makes them a very nice pairing for the show if we're talking in terms of wine and cheese, as we were last week when our gourmet cheese was being delivered by drone. We have some at least one drone story to get to today. But before we do that, let me introduce these wonderfully esteemed gentlemen. First, we have Paul Heald. He's a professor at the University of Illinois College of Law and is just a fascinating person when you read through his biography. Paul, I'm going to just have to quote some of it for our audience because it's not often that we have people who have spent so much time around the world as you have, holding various visiting positions in Buenos Aires, London, Lyon, Regensburg. Where is Regensburg, Paul? If I'm even saying that right.
It's about an hour north of Munich. It's in Bavaria.
Okay. Texas and Vanderbilt University, as well as a good deal of time at Oxford and Cambridge, in addition to having been the youngest faculty member at the University of Georgia's School of Law for then 20-some years thereafter. You earned your bachelor's and master's in comparative literature from the University of Illinois. As an undergrad there, you fenced for the two Big Ten championship teams and placed 18th in, I don't even know, Epee? At the NCAA championships. So you clearly are a Renaissance man, and you've written a novel, correct?
Four, actually, two more coming out.
4 novels. Okay, I I have to throw up my hands and take off my hat and say kudos to you for leading such a fascinating life, and thank you so much for joining us on the show.
Well, it's great to be here.
And Joshua, not to belittle anything that you have accomplished either, and if you have fencing or similar sports in your background, do please let me know. Joshua is a professor of strategic management at the University of Toronto at their management school, which is called the Rotman School of Management. And does fascinating research and study about economics and the digital economy. And we're thrilled to have you on the show.
Thanks very much.
Evan is having Skype difficulties. We are recording this show on Friday the 13th, and Skype is letting us know that big time, or has been at least as we've been ramping up to the show. I understand he is here, though. Hello, Evan.
I think I'm here, right? I need confirmation of that. Good.
You
good.
sound
Yeah. Just wanted to make sure that you mentioned it was Friday the 13th before I announced, my mysterious reappearance. So yeah, sorry for making this 2 weeks in a row with technical issues here. So, but good to be here, and wow, what a great conversation this is going to be. Really looking forward to it. So happy Friday the 13th.
And to you too, Professor Heald, and you are not that far away from each other. He's in Champaign, but my knowledge of Illinois geography is not that great. Is that very far?
Oh, we're just a flyover state, right? So it doesn't matter. We might as well be,
Oh, you're
be in
constantly
Nebraska. Right.
Constantly reminding me of that. Yes.
Yeah. Not too far.
But but your
a couple
paths
hours
have
down
not
the road.
crossed before the show.
No, unfortunately not. And certainly I'm glad they're crossing today. Good to see you, Professor.
Nice to see you too.
All right, let's start out, since our theme for the day is economics. Let's start out with the economics of copyright trolling and look at what's going on with Prenda these days. So Prenda's bet has not been paying off. Prenda Law is an entity that has been suing people right and left over the last couple of years, attempting to shake down individuals and entities that had published works that Prenda purported to have been assigned the copyrights to, has had all kinds of substantive trouble with its claims, and now is paying the piper, this time to the tune of $261,000 in fees and costs to the defendants. This happened late last month, and we haven't had the chance to talk about it yet, so I wanted to bring it up and let people know that Prenda Law continues to get smacked down. Evan, did you take a look at this, and do you see any interesting wrinkles in what's happened most recently?
Well, I don't really see any interesting wrinkles. It's just kind of seems to be the natural unfolding of this thing. I mean, I think we've been able to see Prenda Law's demise for the last few months, better part of a year coming on. It just, continued to get in different forms of trouble, both in the copyright cases and then in some of the new cases that it would file, for discovery. Things really went from bad to worse when it started going after the internet service providers for their cooperation or lack of cooperation in the discovery process. So no surprise here. I think those of us who have been critical of Prenda and its copyright trolling tactics all along, have a real sense of delight in seeing its woes mount, if you will. And so, yeah, I think the most accurate reports show that they made a couple $1 million from their enterprise, and this is, this fee award here is 10% of that. And knowing those guys, well, I don't want to say too much about Paul Duffy or John Steele or Peter. Is it Paul Hansmeier? Robbing Peter to pay Paul somehow. I know something Hansmeier. Knowing them, I just said I wasn't going to comment on their character. So hopefully this will be a sting that is a broader signal to the futility of this kind of trolling as a business model.
Yeah, it's somewhat encouraging to see courts holding Prenda Law's feet to the fire and making them atone for bringing suits that were not legally meritorious. It's not something that we're used to seeing a whole lot of under intellectual property law, which tends to be, I'm massively generalizing here, but tends to give us stories to talk about where a rights holder is able to sue and recover big amounts of money. So, Paul, what do you think about the economic message that's being sent through the failures here that Prenda is going through?
Well, I mean, it's obviously good to see them get slapped down a little bit in general, and this is just not in IP. Courts are really bad about policing lawyers in such a way that actually provides a disincentive for them to misbehave in this kind of way. Like you said, the award is only a small fraction of their overall profit. So it's it's unlikely. I think it's going to provide some sort of massive deterrence, which is too bad. I've got a former student who I think does this the right way, represents a couple of movie companies, and basically he runs a website, and the movie companies send out their cease and desist letters to people who downloaded maybe 10 illegal movies, and the letter contains a link to my former student's website, you go to the website, and it costs you about $20 to officially settle each of the pirated acts of infringement that you've committed, which is, really pretty reasonable. You violated copyright law, you got caught, but, you're not going to jail. $20 a movie seems to be not a bad way to sort of make the whole potential litigation go away. That just seems to me a much more humane business model, and the kind of thing we should be encouraging. And if the judge had slapped him with $1 million in punitives or something, maybe it'd have that effect, but we'll see.
Yeah, your students' model is certainly more economically palatable and public relations palatable
Sure.
than what the RAAA and MPAAA have been known to do in shaking people down for several $1,000s as opposed to something in the neighborhood of 20. It seems like your student is adopting more of a traffic ticket kind of approach.
Yeah, exactly. And, a lot of these people may have downloaded 100 movies illegally. So, it's $2,000 is still a little bit of pain. But yeah, you're right. It's better for public relations for sure. And, I think it remains to be seen, but, it still sends a message. You're admitting that you've done something wrong, and you're paying the price to at least make it partially right. And I think that's, a good, at least a good way to channel the behavior, at least initially, to see if it might, curb some of the abuses that happen on the internet.
Right. Joshua, I know you're in Toronto, so I don't know how closely you've followed or even are aware of the existence of these copyright trolls who were being quite active in the United States for a bit until they began to have the substantive portions of their cases fall apart, and courts began to get very impatient with them. Has news of them made it your way?
There's been a bit of that around. Obviously they've confined their attentions to trolling within the United States. The thinking that the copyright law was going to be behind them on these sort of things. It just strikes me as just one of those blips that you get any time you create an incentive that basically allows you to impose large penalties on people in private actions. So this sort of copyright one it's the same as people throwing themselves in front of, looking like they're throwing themselves in front of buses in order to get tortious liability. So it doesn't surprise me, and it doesn't surprise me that eventually the courts woke up to it.
Yeah,
that's a good metaphor. I hadn't heard that one before in this context, but it can be dramatic. There's and it's I think what one kind of principle we're touching on here is that relationship, or that it's kind of a disconnect, I think, is what we see here in the remedies that are sought in relation to the actual harm. That's what I was thinking about, Paul, when you were talking about your students' efforts of these $20 a pop traffic ticket sort of approach.
Uh-oh.
Skype cooperated for a while and then remembered it was Friday the 13th. So we'll try and get Evan back on shortly. Sorry, go ahead.
Just thought it's not a coincidence that Prenda, I think, is targeting people who've downloaded illegal pornography. I think that allows them to ask for substantially more because of the embarrassment value than the Disney can ask for, Cinderella or something like that. Maybe the metaphor should be throwing yourself naked in front of a bus or something.
Yes, in flagrante, in front of a bus. All right. Well, both Paul and Joshua have done such interesting research and work in the course of their careers. And one of the things that Paul became very well known for last year was some research into the effect of extended copyright terms, and looking at the data and seeing year over year what happened to published works. Was your research limited to the United States, Paul?
Yeah, my research, excuse me, is limited to the United States.
Right.
It requires me sort of determining what happens to works when they fall into the public domain, and that's a lot easier to do here because we know everything before 1923 is in the public domain, and everything after is potentially protected. It's harder to do in countries that use life of the author plus a certain amount of years to measure a copyright term, because you can't just get massive amounts of work and look at the publication dates and know their status. You have to actually track down each author and figure out whether they're alive or dead and when they've died, etc. So I've so far just stuck to the United States, mostly because the data is easier to work with.
Right. So Paul looked at the data and graphed it and very dramatically showed that there is a huge drop off of works that are available to purchase and read once you're talking about works that are not in the public domain. And there's a whole lot of analysis that Paul did around that fact that he discovered that there's this huge dip. And in fact, there's a graph, and it's in the rundown, Alex, if you want to go ahead and show it, because it shows pretty nicely what goes on. So when you get the chance, it's over under this story. But what seems to have been at work here is the fact that there's a shelf life to copyright, and that beyond a certain point of time, people are willing to let their works not renew, not have copyright protection, and begin to not enforce their copyright in the work. Scroll up just a bit, and let's look at the graph. There you go. See how it falls off there? That's in the early 20s. And then you get into present day, where you have books that are in copyright and widely available and popular. People, demand for them is high. So what seems to happen is that authors and publishers were not renewing their copyright, and the books would just automatically go into the public domain. But the logical shelf life for copyright is shorter than the actual copyright term. So the law itself is keeping these books from being available. Have I summarized that without butchering your research too badly there, Paul?
No, that you haven't butchered it too badly. I think there's two stories going on in the graph. The one story is how quickly the drop-off is. The graph is a random. It charts a random sample of books we pulled off of Amazon.com. These are all new books, all books sold by Amazon, and we were interested to chart the initial year of publication of those books and see whether their legal status had any effect on how available they were on Amazon. So the chart shows about 2,300 books, and the first story is how quickly books become unavailable. You obviously see a whole lot of books for sale on Amazon that were initially published between the year 2000 and 2010, which is exactly what you'd expect. But by the time you get to the 90s and the 80s, the number of books drops off substantially. So I think we found in our sample of 2,300 books about 35 books initially published in the 1980s, which was substantially less than the number of books published in the 1880s. So the first story is how quickly that drop-off happens, and that's of course not driven exclusively by copyright law. It's a function of tax laws having to do with inventory, with book inventories. It's a function of business models of publishers who really only want to push books that have been written in the last 10 years or so. And what copyright law does is prevent the normal people who would step in, find the books that are no longer being published, and make them available, probably on print on demand, because that would be the easiest thing to do. But copyright law sort of prevents that from happening until the books fall into the public domain. That's the second part of the story, is that huge spike up in 1923, where once we find a reservoir of books which aren't protected, you have all sorts of folks making them available for sale in new editions on Amazon, and it's quite striking that you have more more books available from the 1870s, 80s, and 90s than from the 1970s, 80s, and 90s at least. When you make certain adjustments to the graph, that's kind of an old graph you have up there, but it tells basically the two stories: the quickness of the drop-off on protected books, and then this sudden explosion of availability once a group of works falls into the public domain.
Right. Mike Masnick had some interesting comments when he wrote this up. He said, entering the public domain can actually renew the value of art and can and does stimulate the economy by allowing others to exploit additional commercial value from a work beyond what was possible under copyright. The commercial usefulness of a monopoly on a book has a shorter shelf life than the monopoly actually granted by copyright law. And in between the pre-1923 public domain books and the books that are new enough to still be actively sold, there are several decades of titles that are no longer worth anything to their rights holders but can't be offered by anyone else because they are still effectively under copyright. So though that gap of books, that missing 20th century, is missing out on the new life that these late 1800 books have enjoyed due to the public domain. Joshua, what do you think of all this?
Yeah, I remember this when this was discussed earlier last year. It seems to me that the problem arises because, unlike patents, copyrights, first of all, they don't actually have to be registered, and you have to keep up to date so that the people holding the copyright can be contacted. And secondly, there are no fees associated with claiming copyright. So when you apply for a patent and you're granted the patent, you can have a 20-year patent on something, but you have to pay a renewal fee, and those renewal fees differ from country to country. The best way to have the renewal fees would actually be to have them steadily rising over time. Now imagine if you had the same things here. Imagine if in order to have a copyright, you had to be registered with the US Copyright Office or something like that. Then if you had one of these books published in the 1950s and you didn't think we were going to sell anymore, well, you wouldn't pay the several $1,000s to renew that copyright that might be required. So you could imagine a situation where, for, say, a decade, you could just register your copyright, and then every decade you'd have to pay some amount increasing over time for that for the copyright work. That's the sort of reform that would be that's the sort of reform actually Disney and the likes would actually support. And it just doesn't get done, and you can see the consequence of it here in this graph.
Paul, I'm curious how it works out for the heirs of people like Jane Austen, whose works are now in that pre-1922 period, so would be in the public domain, and are still, the author's works, although very old, are still very popular. Is there tension there between the fact that the public domain comes into play and the heirs may still feel that there's a justification for monetizing their great-grandmother's work?
Right. I'm sure the heirs feel bad they're not becoming incredibly wealthy from their great-great-great-great-grandmother stories. It doesn't make me feel particularly sorry for them. I mean, the copyright's always been a bargain struck by, the government and authors, and the deal is now, if you write a book, you get protection for your life and then plus 70 years. Back in her day in the United States, it would have been something like, let's say, I think a 28-year initial term and then a 14-year renewal term. But that's the deal. You get this government protection, you get to make a lot of money, and then the public gets to exploit the work for free. So, you have to come up with some sort of non-bargain theory for copyright in order to want to give these heirs, these non-productive, blood-sucking heirs, a piece of the Jane Austen pie. And I think Josh was exactly right. One way to sort of solve the problem is going back to the prior point about the missing books in the 20th century would be a renewal scheme with escalating fees. Back when we had copyright renewal and fees, we had a 28-year term, then a renewal term for 28 more years, and it was a very, very small fee, nothing like the patent fees. And I think the renewal rates were about 3%. So after 28 years, 97% of copyrighted works, registered copyrighted works, would fall into the public domain. 3% still had enough value to be worth filing the renewal paper. The problem is, the whole world now belongs to the Berne Convention, which has been incorporated into the TRIPS agreement, which is the World Trade Organization's treaty having to do with intellectual property, and it absolutely forbids any kind of formalities having to do with copyright protection, and guarantees this massively long term, and makes it impossible for there to be any reform by any country, or it'll put them in violation of their treaty obligations.
Yeah, that basically exports our lengthy copyright terms to the rest of the world, doesn't it?
Yeah, and in return, we import their lack of formalities. If it was just up to the U.S., we'd still have renewals. I think we'd still have required registration, or at least more required registrations. And most countries did away. There's not even a registry in a lot of countries. You can't even register your copyright if you want to. The moment it's fixed in a tangible means of expression, it's protected, period, and there's no place to look up who owns what, and no way to force copyright owners to take any affirmative public steps whatsoever to claim what they own. So things have gotten worse over the years rather than better in terms of trying to create some sort of earlier mechanism that would get works to fall into the public domain that have no value to their owners.
So, Paul, you did this research over a year ago now. Can you tell us, in the aftermath, all the discussion and analysis that has taken place since, if you've learned anything interesting that supplements your work?
Well, two things, I suppose. One of them political, and that is people in Europe are way more interested in this research than policymakers in the United States. So I had 4 trips to Scotland already this year because the governments there consult frequently with academics before they make a move. And in fact, England's just adopted, and this is for all IP, an evidence-based only legislative mandates. In other words, they're not going to change any of their IP laws unless there is data suggesting that changing the law will actually be beneficial to the public, in the senses in traditional sort of economic efficiency terms. So, our scholarship tends to have a lot more traction over there than over here, where, in 5 years, Disney will show up before Congress, there'll be a voice vote, and we'll have another 20-year copyright extension. The second thing is, and this was actually part of the same paper, but it never didn't find its way into the media. And that, at least as far as music goes, it's really interesting the way YouTube solves this problem. Because of the lack of secondary liability for YouTube, a lot of people, well, every day, thousands of people post and upload illegal music onto YouTube. And of course, it gets taken down quite quickly. YouTube has all sorts of mechanisms to alert copyright owners. But copyright owners tend to leave a lot of infringing music up, and they just monetize it by putting an ad. So you actually don't have this problem with music, because you have a market where people who own copies of old music have a way to communicate really cheaply with the rights holder to make that music available to consumers. So you sort of have, people who have the music, people who own the music, and then consumers. And the way that YouTube software works basically makes it really cheap for consumer demand for old music to be satisfied, and for copyright owners to participate in a way that has some benefit for them, and doesn't require them to radically change their business model. So I've been doing a bit more YouTube research, and it's extremely interesting what you find there, what stays up, and what doesn't get taken down. So I don't know if there's a web version of YouTube that might work for literature, but the music story isn't quite so dire.
Yeah, that's a really fascinating point that you just raised, that the music solutions that Google has reached with the entertainment industry might be translatable to things other than music. Certainly movies would be a logical next step, that rather than constantly trying to seek to squash downloads, there would be a way to monetize them. I know that, and of course, television shows too. Just during this holiday season, I was anxious to, in the U.S., the movie The Secret Life of Walter Mitty is coming out during the holidays here. And we were huge James Thurber fans when I was growing up. And there was a television show starring William Wyndham called My World and Welcome to It that my dad just loved. And it's impossible to find. It's not on DVD. No one's distributing it. I'm sure, he could torrent it if he wanted to, but my dad doesn't want to do that. I was trying to find a way to buy it for him as a gift, and there's really no way to do it other than to do it illegally, have someone, torrent it for you and put it on a disc. So I'm wondering, there's certainly a market for that kind of thing. And I'm wondering if there we go. There's James Thurber and James Thurber dog and William Wyndham, if you're watching the video. Do you think that there's any move certainly, the publishing industry might be interested in following this model, and the movie industry?
Right. So, Hulu solves much of the problem, at least for newer television shows. For older TV shows, what's interesting is a lot of times the rights holders don't actually have the works anymore. For example, like the Jack Parr Tonight Show, something like 90% of those episodes were just taped over. So the network, I guess it's NBC, actually doesn't have any copies of a work that they technically hold the copyright to. So who has them? Well, it's crazy people who pointed movie cameras at their televisions in the 50s, 60s, and 70s. And it's YouTube that at least creates the possibility for those people to upload episodes of these old shows. And they're actually not going to get sued for doing that. They're going to either be asked to take it down, or more likely the rights holder will let it stay up, and you'll have to watch an ad beforehand. But it's really quite striking, the percentage of these old copyrighted television programs, which are sort of physically possessed not by the copyright owner, but just by random people out there. It's the internet is really the only hope of making all this old stuff available.
Joshua, do you think there's any solution to the problem that we're discussing here?
Well, in terms of stuff that very few people would want to watch, I suspect that YouTube and others will evolve to pull those out. I'm sort of more curious as to some of the practices for things that I can imagine a lot of people want to watch. Recently, I wanted to show my kids The Sixth Sense, which was the M. Night Shyamalan movie that was so famous 15 or so years ago. And that isn't available via any of these streaming services or purchase on iTunes or any of those formats. There is no Blockbuster to go down and rent them or anything like that. It's actually kind of a hard title to find in any store that might be there, like a Walmart or something like that. Which is just puzzling to me as to why they made that choice. What was the funny thing at the heart of it for a movie that is fairly classic to still be, essentially not using this new forms of distribution? It just is a surprising thing. Now, it is available if we wanted to torrent it, which only makes it more of a puzzle. I don't know if Paul has any ideas on that.
No, I don't. It's somebody in the chat room needs to go online and see whether there's some dispute between, some songwriter with background music who's holding up the distribution of the movie or something like that. It's very odd. Nobody's really done an in-depth study of sort of media business models that I know of that explains why money seems to get left on the table. And if there's time, just for a quick story, I have a friend in Germany who very interested in music from the 30s and 40s and wanted to buy the back catalog of a record company and then reissue all of this old music. And he got together about $200,000, which he thought was a fair offer, considering that none of this music had been sold or issued by the record company for decades. So this was completely dead in their back catalog, not earning them a penny. So he figured, this would be a pretty easy deal. And he approached them, and they threw him out immediately. They just said, "We don't do deals for less than €1 million, and we will not talk to you. We cannot talk to anybody like you, and that's enough. Just leave the office." So here you have this. That's just money on the table that could have been in their pocket, but they have a set business model which says €1 million is our smallest deal, and that's that. I don't know whether the Sixth Sense people have a similar kind of metric that they're following or not, but it's really Joshua, I'm sure, knows much more about this than me, being on the B school side. But there's a lot of, I think, talking to media companies that needs to be done to sort of explain some of the behavior that looks a little bit irrational.
I think these are also poor contracts that were written that leave authors or musicians or whatever vulnerable to this sort of strangeness. I know I put into the last book I wrote, I put a clause in basically saying if they didn't sell a certain number of copies in a calendar year, the rights would immediately revert back to me. And that would allow me to, for instance, something I would want to do is make the book available for free from that point onwards. And I think a lot of people sign these deals without realizing that there are a few clauses that they could put in that could prevent this sort of thing into the future. And I think there's an issue of education about that.
Yeah, I think that's exactly right.
Hey, Evan, I think you're back. Are you back?
I am, I think.
No, you're flat. Yes. Okay, good.
I can't get anything to function properly on this machine today. And I have no idea what's going on in this conversation. And I have no doubt that it's gotten very complex since I left. But I am here and I'm hanging out, and I'll try to ease my way back in.
We're talking about we were talking about Professor Heald's work and the fact that it's somewhat mystifying that there are, beyond the world of publishing, there is so much back catalog music, movies, TV, that there is a market for that is not being monetized in any way except for, and it's not being monetized when it's on BitTorrent. It's not available in any way except illegally in that means. And just trying to figure out, why people are so silly about taking advantage of these products that are just laying on the shelf, that people would very much like to have and like to pay for.
Right. From a cultural standpoint, that's really unfortunate, isn't it? I mean, because there's so much rich stuff. And going back to where we were 20, 30 minutes ago, I mean, the 20th century was this great wellspring of great stuff, Even I'm sure Lawrence Welk is even underutilized these days. Maybe there would be a greater appreciation of those works if they could just be more easily available in the way we want them. I don't have too many, digital copies of Lawrence Welk stuff, but I suppose it's out there somewhere.
No, I've got to say I'm pretty short on that myself. Although maybe in Champaign, Illinois, they have a few more laying around.
Wait a minute. You can't start it's like that.
Sorry. All right. On that bubbly note, maybe we should take a break and talk about a different beverage instead of one that is cold and bubbly, one that is warm and fortifying and gets you through your day. And of course, I'm talking about Tonks Coffee here. Tonks is a small company, if you have not heard of them. They are doing what a lot of people are doing these days. They're committing to giving a really wonderful product, the kind of thing that you cannot get in stores. Because when you're mass marketing something to a supermarket, you just can't pay the kind of attention that the people at Tonks pay to their coffee. So you can't get this in any other means. You can't find it on the shelf at your grocery store. You can't find it at your local cafe, but you can get it direct from Tonks. And the reason that you might want to do that is it's all about the beans. They use only the highest quality, fresh roasted beans, and they source their beans directly from growers. They roast them themselves, and then they ship them within 24 hours of roasting. And that way you get the freshest beans you can find. So it's a really great business model. I really like this concept. I'm seeing it more and more out there for things that people use on a recurring basis in their life. And there's nothing more recurring than coffee. People really need their cup of joe in the morning. Even I, who don't do the caffeine anymore, really appreciate having a good cup of decaf. And I do realize there's some caffeine even in the decaf coffee. So the coffee that you get from Tonks is just bar none some of the best in the world. And what I wanted to highlight for you today, as we sit here on December 13th, is it's a really wonderful gift option for the holidays. What they do is they send whatever bag of coffee size that you would like. You can fine tune that. If you're not a huge coffee drinker, you can get as little as a half bag. You can get their regular size bag, or if you're drinking a lot, you can get more than that on a bi-weekly basis. So every 2 weeks, you get wonderful, high quality gourmet coffee sent to you or to someone on your gift list that you're casting about for. Gee, I don't really know what this person's into. You can be pretty sure that just about everybody loves good coffee. And if you don't just want to leave it at the coffee subscription, and you can tailor that, you can make it a really short subscription or a really long one, depending on what you think they would like and what your budget will handle. You can also add to that. They have these gift bundles where you can include a mug or an AeroPress, which they recommend as the ideal travel kit for brewing coffee, or one of these big Chemex pots, which I remember back from about the same time frame that my family was watching My World and Welcome to It. That was always my parents' preferred way of brewing coffee, and they have stood the test of time and find their way into these great Tonks gift bundles, along with filters that you need to brew in that way. And their ultimate high-end, they call it the full Kringle kit, includes one of those Chemex pots and filters and coffee in a mug, and a great Baratza burr grinder to help you grind your coffee fresh, which they recommend that you do too. So if you're at all intrigued about this for yourself or for those that you want to remember during the holidays, you just need to try a free sample. There's no downside to that at all. If you go to tonks.org/twit, they're going to send you some coffee. They want you to try it because they know you're going to be hooked. Once you give it a try, you're going to really love the way this coffee tastes, and it might just change the way you rethink your morning cup. So you need to try it. These guys are fanatical about delivering the best coffees in the world. They source directly from the growers. Remember, they roast it themselves. They ship it within 24 hours, so it is as fresh as it can be. You're going to get a new batch of beans every 2 weeks, roasted to perfection. It's subscription only. So you got to get that free sample and see if it makes sense for you or someone on your gift list. Go to tonks.org/twit to do that. And I know that the people in your life will definitely appreciate this if you opt to go this way for the holidays. So visit tonks.org/twit today. Thank you so much, Tonks, for your support of This Week in Law. Evan, before we lose you again, I'm going to jump to a story that I want you to weigh in on. And that is here in California, we had I think it's our first revenge porn arrest. The Attorney General's office went after a site that was much like Is Anyone Up, which we've talked about a lot on the show. This one was called
You Got Posted.
You Got Posted. There it is. Similar kind of idea. The crime they were alleged of committing was felony identity theft, and they were prosecuted and convicted for that. What do you think?
I think I don't know that there was a conviction here, right? I think this is the Attorney General making an announcement of some charges having been filed. So, whether there's
you're right. There was an arrest, not a conviction.
Right, and some charges filed here. So, I think to have an intelligent discussion, we've got to just kind of cut to the chase on this and see where this is going. We can backtrack and look at the substantive issues. Clearly, Section 230 is going to play into this, the immunity for third-party content like this. But, revenge porn is obviously a big societal problem. It gets coverage in the mainstream media on a regular basis. You turn on CNN, Fox News, what have you, and they're talking about this idea of revenge porn. It grew from sort of this internet cottage industry 3-4 years ago when we started talking about it to now really mainstream public interest stuff. So the Attorney General of California, Attorney General Harris, she recognizes the importance of this and has to do something and is doing something. And regardless of what the outcome of this particular criminal trial or this criminal proceeding is, whether it goes to trial or the guy pleads out, this Kevin Ball or something, forget his name. Whether he pleads out or that's it. That's it. Whether he pleads out or what. This is just doing more to raise awareness, because if the guy is found not guilty of, I think there are 2 crimes here, identity theft, and also there's an extortion component to it as well. Then if he's found not guilty on those, there's going to be this real public outrage of even a greater fervor than what there is now. And we'll see a revisiting of Section 230 and the state laws that comport with this. We've got to remember the backstory of this as well, is this push by the various states' attorneys general to see Section 230 amended so that the provision, so that one could be would be taking out. It always gets confusing when we're talking about immunity and what's covered by immunity and then what's not covered by immunity. It's the same part of it's the same confusion in the brain that you have with double negatives and all that stuff. But to make it so that one would not be immune for state crimes, for committing state crimes when it comes to this. And Professor Goldman does a great job in his Forbes piece of pointing out the problematic aspects of this prosecution and the challenges that Section 230 or the way that 230 immunity would help the defendant in this situation. But I think the real, like I was saying, the real point of this is that the Attorney General, what she's doing with this is really trying to drive this point home that this is a societal problem. And, if there's not some real action taken and some accountability for website operators, revenge porn website operators, there's going to have to be some changes made because of the seriousness of these grievances. I'll just say that rather than characterize it as a crime, because that's the ultimate issue. Is this a crime?
Right. Kevin Christopher Bollaert, I guess is how I would say his name, Bollaert, 27 years old, from San Diego, is the person behind the site. And per the suggestion of Oddbrain in the chat room, we're going to make You Got Posted our first MCLE passphrase for this episode of This Week in Law. You may be a lawyer. You may be listening to the show in hope of getting a little MCLE credit thrown your way. If that's the case, we embed these little phrases in the show in case your oversight board needs to have you demonstrate that you actually watched or listened. So you can tell them, hey, yeah, I know the phrases for this show. I watched the whole thing and listened to the insights of 2 great law professors and 2 lawyers who, do their best to get their arms around things from time to time. So we hope you will do that. Also, sometimes we get people who are professionals in other disciplines who also can get credit for listening listening to the show. So if you're looking for resources on that, you can go to wiki.twit.tv, go to the This Week in Law page, and we've got them there for you. And do get in touch and let us know how that goes for you. This is sort of an ongoing experiment for us. Joshua, it's just sad to me, from an economic career standpoint perspective, that this 27-year-old from down the road from me here in California decided that his best opportunity in life was to put up this site you got posted, but I guess he's paying the price now.
Well, I guess Mark Zuckerberg started with hot or not.
Right.
Back in Harvard. I guess this is sometimes the first thing that occurs to people. I don't know whether it's a loss of entrepreneurial, fervor that might have graced our futures. I think this sort of thing is part of the society finding its own equilibrium with respect to privacy and with respect to what is acceptable behavior in that regard. I think we've had this technology open up, basically the notion of intellectual theft more strongly. It just wasn't something necessarily there. I think in the past, it wouldn't have been a digital site. It would have been private extortion, especially people who had, in times when that was a problem, who had issues with, conflicted about their sexual orientation and being public about it. I think those also gave rise to these sorts of things. This is just another kind of example of that. It's the sort of thing that, again, has to emerge for the law to become clear on it. And I think that's the process of what you're describing right now.
Paul, I'm curious whether you've thought about the intellectual property gloss of revenge porn and people being able to use their IP rights to prevent or seek redress.
Well, as a victim of revenge porn, I really hope that something can be done about it. No, just kidding. So I'm not sure there's really any interesting IP issues having to do with revenge porn. I mean, the person who takes the pictures, the owner of the copyright, but that's not a defense to a typical, privacy claim. So what's interesting to me in general frequently is when we need to have criminal sanctions because civil sanctions aren't enough. It seems to me crystal clear that the victims of revenge porn have a privacy cause of action against the person who took the picture and posted it. And I also think, in fact, that the Communications Decency Act doesn't provide immunity for this particular kind of website, which invites and incites the behavior. There's been some courts that have been willing to find an exception from immunity in situations where the website is specifically designed to attract privacy violations or defamation violations or stuff like that. So I think that this guy's got civil liability, but it's apparently not enough, right? I mean, the threat of being sued by any number of different potential victims hasn't prevented him from running the site, which suggests that criminal sanctions are appropriate. But I think Eric's analysis his legal analysis is pretty on point. The case for criminal liability under the law, that the identity theft law, is I think rather weak. What intrigues me is whether this is blackmail or not, and why not just charge under your typical blackmail or extortion statutes. And I guess the problem is the video is already out there, right? Blackmail is usually pay me $100,000 and I won't post the picture of you on the internet. Here the picture's already up, and you're charging people to take it down. So you're not sort of threatening to expose them or reveal new information. It's already up. I suppose that would be the argument of the defendant. On the other hand, I mean, if I were the Attorney General, I'd try to argue that In essence, it is blackmail, this threat of we will keep it up, because there's always people who haven't seen the picture yet, right? Just because it's on the internet doesn't mean everybody's seen it. So it is seen as an ongoing threat to expose the picture to people who have yet not seen it or may not even know about it. And that way you can fit the cause of action, more neatly into a conventional frame without, freaking out, First Amendment advocates and people with legitimate concerns about what the state's actually chosen to do in this case.
Okay, we've alluded a couple of times to Professor Goldman's Forbes piece on this. If you're looking for that or links to any of the other stories that have formed the basis for our discussion today, head on over to delicious.com/thisweekinlaw/239 and you'll find them all there. We've got an Illinois story for dropped in here because it's timely and because Evan and Paul are both there. And that is that Illinois is considering making illegal the use of Google Glass while you're driving. Evan, have you looked at the proposed law and what do you think?
Well, I mean, it certainly has some political currency to it. And there was the story from the California woman who got that ticket for speeding and then tacked on the violation of the California statute for distracted or having a device that would make the driving distracted. So there's been a bill introduced in the Illinois state legislature that's meant to target Google Glass in this respect. And so Illinois is not the only state here. I mean, this particular piece was from one of the suburban Chicago newspapers here, the Daily Herald. And so it kind of takes the bent that, Illinois could be the first to actually ban this. But there's legislation in other states. I want to say Maryland is one of them. But it's in the article somewhere where there's been some other legislation here. So, we should find this as no surprise that legislators would see this issue as an ability or as an opportunity to introduce legislation that serves the public interest in this way. And again, for the third time, this is the third time we've talked about this Google Glass driving issue. I think that's perfectly sensible to make the wearing of devices, the use of devices like that unlawful because of the public safety issue. So it's interesting to see the various states' legislatures doing that. I heard someone.
Yeah, it's me. It just seems like it sounds to me like these types of laws. This is exactly. It seems the same model as you've got posted. Mm-hmm. Basically, this is revenge legislation.
Ooh, I like it.
What think about it. There is no evidence at all yet that Google Glass is causing a public safety issue. There just isn't. Now, it's with these new technologies, people sit there and they anticipate these problems, and that's what they use to put in legislation. And then we, of course, see them go away. I mean, we've lived for years under the tyranny of not being able to turn on electronic devices on takeoff and landing. We've lived, there were other technologies like immediately the Segway was released. The first thing whole lots of city councils did was ban it in the interest of public safety. But what they're really trying to do, it seems to me, is open themselves up demonstrate their power for a lobbying effort from technology firms. And in this case, it would be Google. A century ago, we saw the same things with respect to the motor vehicles. Cars were introduced, and immediately local and state governments introduced all sorts of laws, such as, these are a terrible hazard. In order to use a car, you've got to have somebody walk in front of it with a flag, waving people out of the way. It's the same sort of thing. Now, I don't doubt that there are certain technologies for which we would be more concerned about public safety. Obviously, all the pharmaceutical products and things fall into that class. But Google Glass doesn't necessarily satisfy that. And at the very least, you wouldn't pass legislation without there being a comprehensive presentation of evidence on this. And that just doesn't seem to be the case at all here.
Well, of course, we don't have a lot of good evidence on it because, only like 10,000 people have been issued their test, devices, and it's going to be coming out into market later. But I mean, with that said, I don't know that we need to make too big of a analytical leap to an area where there's tons and tons of empirical evidence about distracted driving, with cell phone use and texting, and, whether or not there's a lot of evidence, that's been perfectly scientifically vetted. I think there's you can look at plenty of tragic situations where people have lost their lives and lost their limbs. And, I won't appeal too much to emotion here, but I don't think you would have to be real persuasive to somebody who'd lost a family member because of somebody crossing the center line when they were sending a text and killing their loved one here. So, with all respect, I see no comparison whatsoever to the tyranny of not being able to use an electronic device on an airplane, because that's not anything that's going to be distracting the pilot. That's you sitting in your seat. I mean, sure, it could interfere with all that. So, I just don't know what more we would need here. I mean, it's clearly a device that allows you to use the internet. There's no doubt that it would be, presenting a ton of content right there in a way that would be difficult to externally validate whether it truly is, whether somebody's using it responsibly. So, I'm certainly willing to hear what kind of sensible alternatives there would be to banning the use altogether. But given the public safety and, the risk to human life and, life and limb, the real literal risk here, I just don't see a more sensible course than going ahead and trying to ban this stuff. Why do we have to wait till people die in auto accidents, using Google Glass? Why do we,
Because
why does that have to happen first?
We don't even know if that would lead to people dying. I mean, when it comes down to it, the biggest risk of distraction for people in cars is, for instance, driving with children who are in the back talking to you and asking for things. That's a terrible distraction, but nobody has yet banned children from cars. Now you're going to
Can we
argue
do
with
that?
me.
Can I make my son get a ride with someone else for a little while? That would be definitely enhancing the safety of my driving.
You'll enjoy the long walks that you'll be able to take. But my point is that all of these things, when you think about banning, involve costs and benefits. And the reason we don't ban children from cars is not because we don't think they're a distraction. We know they're a distraction, but obviously the costs would be too high, and we're not sitting there weighing all the potential loss of life either. What I'm saying with Google Glass is it's not even clear that it is a distraction. It's not clear it's a distraction at all. It's not clear that, in fact, Google might have been putting things in it that would make driving better. It might be easier to follow a road, follow directions, for instance, compared to a little GPS thing in the car using Google Glass. And so to slap on a ban right at the start seems very presumptive when we haven't actually, none of these states has chosen as a matter of their values that they're going to eliminate all distractions from cars. So again, you've got to ask yourself, why are they picking on this thing that hasn't been brought out? We're not sure if there's even been responsible for any accidents. There's ample laws already to take into account negligent driving and other things causing that. And there are other remedies, such as discussions with Google about what might be distracting and what might be causing things, and how that can be addressed through appropriate education, as opposed to leaping in and banning it on essentially a theory, and it may be a good theory, but it's just a theory regarding potential harm.
I would like to see some scholarship on this, some pretty rigorous testing and analysis, maybe coming from the insurance industry, maybe coming from a more independent quadrant, to find out, exactly where we fall on the continuum. Is this going to be, and I'm sure it would vary device to device and functionality to functionality, whether something's going to be a danger or perhaps a benefit to driving. And I think, as Joshua says, I tend to agree, it's too early to really know yet. And I'm not sure how we're going to know. I am hesitant, Evan, to let the way we know become, let 1,000 accidents occur or more. So I'm kind of stymied as to how we solve that problem. Paul, do you have any thoughts?
Yeah, I'd love to know how many accidents are caused by people using their GPS. That seems to me just as distracting as Google Glass.
Yeah.
I'm a cost benefit guy. So, if the benefit of Google Glass or texting is incredibly low, then for me, it doesn't take much of a risk to justify the ban. I mean, I would want to know what people are using their Google Glass for. If it's for,
Let me tell you what a lot of guys use the internet for.
While they're driving down the road?
Guys are idiots.
So you want to ban guys from the road?
Guys and kids off the road.
Basically,
right now.
it'll be the opposite of Saudi Arabia. Only women can drive and be in cars.
Maybe that's progress.
Yeah. I mean, there's options other than bans or no bans too, right? You can have sort of a middle of the road law where it's not per se illegal to use your Google Glass. You're not going to get a ticket, if you get pulled over for speeding and you happen to have Google Glass, but you could have it as an enhancement when an accident does happen. So if you kill somebody while you're using Google Glass, then there's some sort of enhancement on the penalty phase. But in other words, you're only in trouble if the device you're using actually causes the accident. And states haven't taken this. You could take it with texting, for example. It's okay to text, but run over somebody when you're texting or you're going to go to jail for 10 years. There are middle grounds which legislatures usually aren't very good at identifying or being very creative in choosing.
All right. Well, we have so many other good topics in our rundown, and I'm not sure that we're going to get to all of them. But I did want to hit on at least one of Joshua's blog posts, maybe a few. Joshua does a blog called Game Theorist, Musings on Economics and Child Rearing, that is full of fascinating stuff, including the concept of data-driven parenting. And Joshua, a little bit earlier, you were alluding to, this tension in our society today between trying to figure out how much privacy we're all entitled to and how that shakes out as far as the law is concerned. So that's very much in play here, I think, because the whole notion of data-driven parenting is having statistics and data points on your children and their activities and behavior, down to the fact that apparently there is a digitally enabled diaper available. Can you tell us about that?
Oh, I think there was I saw it. I don't know if it's actually available, but I saw a startup launch with that idea. In other words,
let's hope
they put inside a diaper some sensors that would allow you to do all manner of things and tell all manner of things without having to actually use what you used to do, which is smell.
Right. So it's the same concept of those devices you can put in your car that tells you all the diagnostics and things about your car and its performance and gas usage and stuff. But this would be geared toward your kid's cute little bottom.
I mean, and I'm supposed you could gather a lot of information about that. I mean, there are other apps that also allow you to do that. There's some rationales for that. It just occurred to me. It seemed to me that was stepping over the line of usefulness and other things like that. Good luck to. I expressed skepticism that this was going to be a very successful business.
I think I've just decided that the only child I'm letting ride in my car is one wearing a digital diaper.
Okay, well, at least you know what the smell was.
That's right.
It could send you an alert to your Google Glass telling you to do what exactly, I don't know.
Turn around and look at your kid.
Exactly. But we see all sorts of things. I mean, this is a constant tension. The other thing that was a big discussion this week was a toy released that had an iPad, a potty training thing, a potty basically with an iPad holder on it. And there was a lot of discussion that had sort of crossed over the line of reasonableness regarding dealing with kids. That I was less concerned that I can see that that from the parents' point of view, toilet training takes a lot of time. What's the difference between them having access to an iPad versus watching TV while doing it or something like that? So I was less concerned about the outrage over that. But this happens all the time. There's a lot of discussion about the integration of technology of various kinds into devices and toys for children. And as per usual, there are lots of reactions regarding whether, there's safety reactions which are of course fair enough, and there are testing procedures for that. But there are just reactions about whether, you should allow technology to creep into parenting that much. And I think it all depends. My guess is that different parents have different needs and desires to know various things about what's going on. And if there were sets of parents out there who wanted to keep a lot of data about what's happening with their kids, then good luck to them. But otherwise, it's not going to be necessarily useful to everybody. And it's also there is also this residual concern: is are you going to be able to use that data usefully? If you were able to correlate the bowel movements of your children with what they were happening to eat that day, then what? Is that a good thing? Is it a bad thing? Do you want more or less of it? I don't know. Those would be the sorts of concerns. But my suspicion is that, even if this stuff produces lots of data or whatever, ultimately parents don't have the time anyway. It might look like a good idea at the time, but these things aren't really going to take off.
I don't know. I could certainly gaze into a crystal ball and see not just the parents wanting this sort of data to help them make decisions about their children and, dietary and otherwise, but the whole commercial sector, which just loves being able to get all kinds of fine-grained data about consumers.
Right.
I could see them being just completely on board with the notion of monitoring kids in very detailed ways and finding ways to use that data. And so that raises a couple of points. First, the kids have no say-so in this. They're too young to be able to object, and by the time they're too old, it's probably too late. And secondly, the parents who might be doing this for their own edification at first might not be aware. I could certainly see some sort of product or monitoring device being put out for all the great benefits that it gives parents, with a whole hidden agenda having to do with what can be sold to them. So where do you think that's all going?
Well, it's already very difficult for companies to collect data of any kind regarding children under the age of 13. So the good side of some of the legislation like COPA is precisely that, but to prevent that sort of information being collected, at least without very clear understanding from the parents. So that's why kids aren't allowed on Facebook, for instance, for that same purpose. At the same time, it's difficult from where I sit to see this as so fearful, and to see that it would really, really become a tool for exploitation anytime soon. I just think companies have had enough trouble trying to pass the data they're already collecting from things like just internet usage and the like, and internet behavior, to really delve in it to this level. Ultimately, I think what is more useful is that what parents often need to understand and what they want to know about is this normal? In other words, I would think that was the greatest, when they see some sort of behavior or something they notice about their children, they want to know how far it is away from normal. Sometimes they want to know that for reasons that they don't want their kids to be normal. In other words, they want their kids are speaking early or something like that, and they want them to be normal on some sort of upside. But for the vast majority of health-related things, you want your kids to be closest to normal as possible, and you sometimes just don't know what it is. And that also includes for things like teenager behavior or funny spending habits and things like that. How much time should they be spending doing computer games? And the best spend, this data could ultimately get a better picture of what is normal, and could be useful from that perspective. So I don't necessarily see I think the sinister side of these things are very hard to exploit, and there probably isn't that much return into it. There is probably more return into just collecting data and being able to tell something about average behavior, in which case it's less sinister.
Evan, what do you think about the Internet of Things invading your children's toys and apparel?
Well, it's an interesting spin on the more general concept of the quantified self. It becomes like the quantified family then. And, anytime we start thinking about these things, I sort of get a sense of we're living in the world that the Jetsons lived in. It seems like, part of some of the unseen scenes in the Jetsons where, what was going on in the kids' bedroom with some of this data collection. So, but I like where we're going with the topic about the privacy here. And this relates also into an issue I think of in some of the other writings that you've done with the the notion of the kids' identity and their privacy interest and what's the value of this information and what are the interests that we have in not making sure that this information becomes public later, sort of the digital identity. When a kid is wanting to talk about homecoming dates, you may not want to have access to a database of what the diaper usage was like a few years ago. So there's a lot of different interests that come into play here as a subset of the issues dealing with the quantified self, and we can kind of spring off in discussion on any of those.
So I've heard a lot about these things. I mean, one of the biggest discussions I have with many parents, especially of kids who are around the age of 12 to 15, is, do they get allowed to go onto Facebook? Do we really want them doing that? And part of the concern is about bullying, but Emily Bazelon from Slate has written a wonderful book that basically shows that bullying has always been pervasive, and if you see it online, it's just because it's been taken out of the playground, and it's still the same sort of bullying. I think with regard to, but then there's this other concern about doing things that will embarrass you in later life. And there is a sense in which, that's a concern. People's childhood come back to haunt them. Mitt Romney was accused of all sorts of things when he was a teenager, came up during the presidential campaign, but ultimately, people are fairly, even from those points of view, people were fairly dismissive of things that occurred when people were younger, those sorts of choices. And I think this will become more so. It would not surprise me at all that in 10 years' time, whether somebody had literally naked pictures of themselves on the internet will just not play a role whatsoever or raise a concern for not only employment, but for things like, having a political career and stuff like that, just because it will become more pervasive, just because these things will have happened and happened in a youthful way. I think the bigger concern is actually when you're older and you're supposed to know better and these things come out. That will be a whole different matter. But from the point of view of this sort of fear of the parents have that some sort of behavior will get out there on the internet and it will ruin your life. For the vast majority of kids, that's just not going to be the case. And it seems to me that the earlier you introduce the kids to social media, especially when they are happy for you to be looking over their shoulder and still be your friends on Facebook and stuff like that, the better it is. I've had situations where I've watched conversations between my daughter and her friends on Facebook, and and occasionally I've seen her say things that she sort of got, that were not appropriate or whatever, and we've been able to discuss that. As she gets older, those opportunities won't be there, and moreover, if you're the sort of parent who denies your children Facebook, they'll find a way to be on, and they'll be on without your knowledge and without a clear means of talking to you about it. So you won't have any role at all. So it seems to me that this has to be, you have to be far more relaxed about it and proactive instead of defensive.
Yeah, I couldn't agree with you more, Joshua, particularly given you pointed to a story this week about Instagram now becoming more like Snapchat and having private messaging capability. Right. If you're one of those parents who decides, I'm going to monitor and control everything that my child does, they're going to find ways to talk to each other without you having the ability to monitor and control.
But you have to actually see it's a real thing. I mean, it's actually a good thing. My daughter, after years of being on Facebook, all her friends were on Snapchat. And I saw her using one day, she was using Snapchat. She basically looked in the camera, took a picture and sent it to her, whatever friend she was doing there. And, you can look at that and you can say, oh my God, that means they can do things we can't see. It's the end of the world. But here's the point. She decided to use Snapchat. She decided to use Snapchat because it wasn't going to have a life of its own on the internet. Mm-hmm. Because she took control of her own identity. Every kid who chooses to use Snapchat rather than Facebook or Twitter because they want to keep whatever's going on private has already learnt the messages you want to teach them.
Yep, that's an excellent point. Of course, they're arguably keeping it private from you too, if you haven't had that kind of early relationship that you were talking about, Joshua.
Well, no, that's true. Yeah. But there comes a time also where you don't want to know. There are things that I want to know about my daughter or my kids if they are, there's something dangerous going on and it's really outside of bounds. But most of their behavior is fairly repugnant to me, and I'd rather not see it.
Yeah, I'm starting to get that. I have a 10-year-old, and I'm beginning to understand. Well, for all of those who wanted to know or can't fathom how anyone would want to know what's going on in your kid's diaper, let's make diaper data our second MCLE passphrase for the episode. And let's get to our tip and resource of the week. The tip is 10 tips, actually, and they're from Cash Hill over at her great Not So Private Parts blog. We've been talking about privacy, and she has 10 incredibly simple things you can do to protect your privacy. And I really liked it because they were simple and they're things you may or may not have thought about before, or you may not have thought about doing all of them. And they include things like having a password to protect your devices, putting a Google alert on your name so you can see how your name is being used online, how it may come up, signing out of your online accounts when you're done with a device or done using that account, and 7 more that I'll let you go check out on your own. They're sort of dead simple, but if you're not doing all of them, they're really simple things that you're just missing, and you probably will kick yourself and go, yeah, I should have been doing that. Secondly, our resource of the week is not quite so simple at all. In fact, it's quite complex, but I wanted to throw it out there. It's from infojustice.org. It seems to be going hand in hand with the Global Congress Research Survey, whatever that may be, particularly looking at creative economies and practices. And it's a bunch of suggestions from folks, some of whom, at least one of whom I recognize we've had on the show. Greg Listowka is who I'm thinking of from Rutgers. And what these smart people have done here is identify areas that need more research. And there's a whole lot of emphasis on the copyright field, particularly, oh goodness, I'm not even going to try and pronounce this person's name. They are from Amsterdam. But talking about the lack of official registries for copyright, due to the fact that copyright protection is not tied to formalities. We were discussing that earlier on the show. So these are all suggestions. If you're a researcher or someone who feels that you might be interested in doing research in the areas that we discuss routinely on this show, these are all kinds of areas that are ripe for you to jump in and shed some light. So I wanted to include that as a resource of the week and possibly inspiration for some of the folks who listen to the show. And I've had so much fun doing the show today with Paul Heald from the University of Illinois and the law school there. Paul, it's been really great speaking with you. Can you tell us if there's any sort of final item on your mind that we didn't get to talk about today, or anything coming up that you think that our audience might be better advised coming away with?
No, I've just been imagining a New Yorker cartoon where an esteemed economist in twill looks down at a little baby wearing a diaper and says, "Your data is crap."
Yeah, we need that illustration for this show. That would be good. Chat room.
Thank you so much for having me. It was a delight.
It's been a real pleasure. And also Joshua Gans, so great talking to you. I've really enjoyed getting acquainted with your work and prepping for the show. Love the blogs that you write and the research that you're doing. And you have lucky students. They're in a great position being able to have your insights on a day-to-day basis.
Thank you very much. And I've enjoyed this conversation. Thanks.
Evan, how you doing there? You still with us?
I think so. I'm never relying on that too much. I just, come in and, say hello once in a while and try to, whatever. It's one of those Fridays, One of those Fridays where,
no, you've definitely, I've not quit. Skype has been with us for, I'd say 3/4 of the show on your connection. And in the meantime, at least you've had some good time to continue growing facial hair.
That's right. Yeah, the holidays coming up. Got to stay warm, Paul knows this just down the road. I mean, I think the whole country knows how cold it is, but especially here in the Midwest, been in the deep freeze. So, it's beginning to look a lot like Christmas.
There we go. You look a little bit like Will Wheaton from that angle.
That's what people say.
So we've had Will Wheaton on the show.
That's what people say. I'll take that, until, less until Will Wheaton does anything more insane. I'll live with it.
There we go. You could be his beard double, should one ever be called for. All right. Well, we're going to have one more episode. We'll have episode 240 next Friday before we take our holiday break. Got some echo there. We're going to have Chris Savage and Larry Downs join us next week, so you won't want to miss that. We record the show at 11 o'clock Pacific time, 1800 UTC. And we hope that you can join us live. That's at twit.tv. Jump into our chat room. If you do that, that's at irc.twit.tv. And if you can't join us live, never fear. You're going to be able to listen to the show on your own schedule on demand. Just go to twit.tv/twill. You'll find our whole archive of shows there. If you'd prefer to get it on YouTube, you can find us there too, youtube.com/thisweekinlaw, on Roku and in iTunes as well. And if there's any other way that you would like to get the show, let us know, and we'll make sure that I think it's probably already is available in that format for you. We can just tell you how. Again, at twit.tv/twill, there's all kinds of information about the various formats the show is available in. What else can I tell you? Not too much. This has just been a really, really fun show and edifying and interesting in many different ways. We hope you've enjoyed it too. Be sure and find our guests and Evan and me offline when you have a chance. We all have presences, various places that you've been seeing in the lower thirds, etc. during the show. Also, you can find the show itself offline, not just at twit.tv /12. No, not offline, but not during the show, if you get my drift. You can find our Facebook page and on Google+. Go over there, let us know what you've thought of the show, what you'd like to hear us talk about on future shows, and people you might like to hear us speak with. We love getting your insights and thoughts and suggestions in all of those formats. And email us if you'd like. Evan is evan@twit.tv. I'm Denise at twit.tv. And until next week, this has been This Week in Law. Thanks so much for joining us. Bye-bye.